Hi all, this is Avnish Tiwari, faculty St. Peter's Law Academy, Delhi. I welcome all of you in the regime of St. Peter's Law Academy. Today in this video we are going to talk about one statute from the codified Hindu law. But before that, when we talk about Hindu law in general, we talk about four major statutes. We talk about Hindu Marriage Act 1955, we talk about Hindu Succession Act 1956, we talk about Hindu Minority and Guardianship Act, we talk about Hindu Maintenance and Adoptions Act. So these are the major codified laws which are going to constitute the major chunk of this codified Hindu law. There are certain things which are uncodified as well. So we are not going to talk about these whole codified body or the corpus of Hindu law, but we are going to talk about only one statute of these major four statutes, only one. And I have picked up the Hindu Minority and Guardianship Act 1956. We will talk about this, and in short we call it as HMGA, Hindu Minority and Guardianship Act. So we will try to have an overview of this statute, means what are the provisions and what are the basic ideas under different provisions of this act. So just I will write the statute. It is the Hindu Minority and Guardianship Act 1956, and in short we call it as HMGA. So I will use this HMGA expression time and again while I will be talking about this particular statute. So the very first question which comes to your mind, or it should come to your mind, is who is a minor? Because we have different statutes and we talk about different concepts, different ideas. Under different statutes, we talk about different objectives of a particular statute. Means if there is any statute, there must be some purpose behind the enactment of that statute. So similarly, we are having this act, means we are going to protect the interests of minors under the Hindus. Means we are going to protect the person of the minors, and we are going to protect the property of the minors who are Hindus. So that protection can be done by the guardian. So the idea of minor and the idea of guardian, these two ideas are going to constitute the core of this statute. But the very first thing is that minority. So in common parlance, what do you understand by minority? Although this concept of minority is related to the age of a person, but in common parlance, minor is a person who is incapable of doing certain things, like a minor cannot give a valid consent. So the concept of minority is here under this statute. The concept of minority is there under the Indian Contract Act. The concept of minority is there under the Partnership Act. So the idea of minor or the minority can be found under different statutes. But here when we are talking about minor, it is a kind of incapacity. Minority is a kind of incapacity. It is a kind of incapacity. Means because of the minority of a person, that person is unable to do certain things. And if he is not able to do certain things, means he is incapable in so many ways. Means the minority of a person is bringing so many incapabilities in that person's life, but still that minor person's interests need to be protected, and for that purpose we need to have guardian of that minor person. So these two ideas, that is minority and guardianship, will go hand in gloves, means together. Let's start with this act. Let's start with this Hindu Minority and Guardianship Act. I am writing this HMGA. So what is the scheme? Means how the provisions are arranged under this whole statute. We are going to have an overview of the whole act. Means we are not going to talk about each and every provision in detail right now. Rather, we are going to introduce all those provisions briefly and in a peripheral way, so that we will be having the basic idea about the whole structure of the act, that is the HMGA. So what is the scheme? First of all, we try to understand what are the objectives behind the enactment of this particular act. So the preamble will talk about the objectives. So the preamble is very important. Preamble of the HMGA. The preamble talks about two things. The first thing is that amendment, and the second thing is codification. AC, we can call it AC. The preamble talks about the AC. AC means this act is going to amend and to codify certain laws pertaining to the minority and guardianship. Means there are certain laws already, and those laws are going to be further codified or further amended by the help of HMGA. This is a preamble. So you can use this acronym AC. Amendment and what? Codification. Because for your prelims examination, these two words are very important. If you are going to appear in the preliminary examination of Haryana Judiciary or any other judicial examination in which family law is a part of the syllabus, this may be asked that the preamble of the HMGA talks about what? So you will give the answer in terms of AC. A stands for amendment and C stands for codification. And now we have total 13 sections in the HMGA. Apart from preamble, we have total 13 sections. Total 13 sections. So we are going to introduce all those sections, although briefly, in this whole video, in this whole interaction. So now my focus will be on sections. So I will talk about these sections one by one. Section 1. So whenever we are going to talk about a particular statute, we need to have the bare act of that subject. Suppose we are talking about HMGA, so you must be having the bare act in your hand, because without having the bare act, you will not be able to have the real picture. It gives you the feeling that yes, in a real sense, you are referring to different provisions under this particular statute. So make it a habit that whenever you are going to study any statute, that statute is there on your table in your hand, because sometimes you have to refer to the conceptual part and sometimes you have to refer to the factual part. Means you have to refer to the index, means what is the section number in which definitions are provided under the Hindu Guardianship Act. So, the answer will be section number 4. So, this factual question will also be asked. So, what is the title of section 1, title of section number 2, 3, 4, 5, like that. So, this is something you need to memorize time and again, and then only you will be able to answer these factual questions as well, because the conceptual part is something I will be dealing with you in the class or maybe in a video which is lined up. So, section 1 talks about the short title of the act, means this act may be called as HMGA. So, that is not something we need to talk about right now. Short title means this act may be called as Hindu Minority and Guardianship Act 1956. So, section 1 clause 1 talks about the short title, and its clause 2 talks about its applicability. Means in what areas Hindu Minority and Guardianship Act is going to apply. Territorial application. So, it is going to apply throughout the territory of India. There is no exception, because earlier, before 2019, in every statute what we used to read that this act extends to the whole of India except Jammu and Kashmir. But now that part is gone forever, and now this act in the similar way is going to apply throughout the territory of India. And it is also going to apply on those persons who are domiciled in any part of India, but right now they are residing in some other country. So, the domicile of the people is an important factor for the applicability of this act. This is section number 1. What is section number 2 talking about? Section 2. This act is supplemental in nature. Supplemental nature of the act. Section 2 talks about the supplemental nature of the HMGA. So, what is supplemental? Means the main concept or main law is somewhere in existence, and this HMGA is going to support that law, and that is why it is supplemental. So, for your information, we have other laws also which are dealing with the concept of guardianship. Like we have the Guardianship and Wards Act of 1890. So, the concept of guardianship is contained under that act also. So, every now and then you will find that that act is also coming into the picture. It means this act, the HMGA, is going to talk about the guardianship and the minority, but it is not the only law which is going to deal with these issues. There are certain other laws also apart from HMGA which are still applicable on the concepts of minority and guardianship, and one example is that act which I mentioned earlier. And section 3 talks about the application of the act. Application. So, this act applies on Hindus. Act applies on HMGA applies on Hindus. So, now the question is, who is a Hindu? So, who is a Hindu? That question may be understood with the help of section number 2 of the Hindu Marriage Act as well as this section number 2 of HMGA. So, I am not going to enter into that realm of who is a Hindu, but this act is going to apply on Hindus, that is for sure. And when you go through the clause, section 3 clause 2A, it talks about one word, and that one word is, if you read the bare act, you will find that word. You go to the bare act, Renenkans. The word is Renenkans. Renenkans are those people who are residing in Puducherry, and they had the right to decide their own law. And in some situations, even today, the French law applies to these people. So they are called Renenkans. So this HMGA is not going to apply on Renenkans of Puducherry. It is written in your bare act. You can refer to that clause 2A of section 3. So that is also very important for your preliminary examination, this clause. For your pre-examination, it is very important. Try to understand the meaning of this word Renenkans. Try to catch this word. It is very important. And then comes section number 4. Section number 4. And section number 4 is talking about the definition of what? Minor, and the definition of guardian. Minor and guardian. So we have different clauses of this section number 4. We have ABC. We have ABC, and the idea of minor is given under 4A. Means any person who is less than 18 years is a minor according to the definition of minor. So if somebody is asking as in who is a minor under the HMGA, your answer will be any person who is below the age of 18 years. That person will be a minor. And when you go through 4B, it talks about guardian. So different types of guardian are mentioned under this 4B, and guardian may be, for example, natural guardian NG. 2, any guardian who is appointed by the will, testamentary, by will, and some guardians may be appointed by the court. And fourth, it goes like this. I will read it for you from the bare act. It says that any person empowered to act as such or under any enactment relating to any court of wards. So as such, any person who is entitled or empowered to act as guardian, as such, empowered, or under any law or any enactment dealing with the court of wards. So what is a court of ward? I will talk about it later on, but these are the different types of guardian mentioned under clause B of section number 4. And what is clause C? For C. 4C says that natural guardian means all those guardians which are mentioned under section 6. So 4C is giving us the reference of section number 6, and section number 6 talks about those people who can be the natural guardians. Natural guardians. Section 6 talks about natural guardians. So under HMGA, only 3 persons can be the natural guardians of a minor person. And who are those 3 people? father, mother and the husband. Three types of persons. One is the father, second one is the mother, and the third one is husband. So these three persons can be the guardian of the minor, means the natural guardian. So there is a deep concept, there are certain circumstances. So once we will start these provisions in detail, I will bring those details at that time, but as of now we need to have the structure in our mind, so that I am providing you the structure. So section 6 talks about different types of persons who can be the guardians of minor. Section 5, because we are done with 4 and 6, but we just jumped over section 5, but we need to refer to section 5 as well, because section 5 is going to talk about the overriding effect of HMGA, because HMGA was enacted in the year of 1956, but before that year there were certain laws, certain enactments, certain customs, certain rules to govern the concept of guardianship and minority. One thing we are missing out right now is the idea of minority. Idea of minority is there under section 4, but the real concept of minority will be dealt with by the help of the Indian Majority Act 1875. I will bring that into the picture. But section 5 talks about the overriding effect of HMGA. It means all those old laws, whether those laws were in the form of custom, whether those laws were in the form of some rules or some other form, all those laws will cease to operate when this Hindu Minority and Guardianship Act became effective. It became effective on 25th of August 1956. So before that date we had certain laws, so now all those laws are going to cease from that date, but yes, certain laws which were not repealed, they will still be operational, they will still not be dead, they will be applicable. For example, the Guardian, the Court, the Guardians and Wards Act 1890, that act is very old, but that is still applicable. Why? Just because that act is not repealed by HMGA. So now we have the idea of these certain sections, and after that we have section number 7, section 7, which talks about the guardian of an adopted child, and that child is a son. Guardian of adopted son. So what is the content of this section? Suppose there is one person and who is having one son, and now I am a third person who is going to adopt that child. So I am not the natural guardian of that child, or I am not the biological or the natural guardian of that child, but still I am going to adopt that child, and after the adoption I will become the adoptive father of that child. So section 7 is simply saying that in case when a son is adopted by a father, that adoptive father will become the guardian of that adopted son. It is not very conceptual, it is very factual. And after the father, her mother will be the guardian of that adopted son. And then comes the powers. Powers of the natural guardian. Powers of the natural guardian. Section 8. Section 8 talks about the powers. Means when there is a natural guardian of any child, so being the natural guardian does not entitle you to sell the property of the minor. You can't do that. You can't sell it, you can't lease that property for more than 5 years, etc. Means if you are going to do that, you will have to take the permission of the court. Means you can't mortgage the property of the child, you can't charge it, you can't sell it, you can't exchange it. Means the immovable property of the minor will not be transferred by you unless you get the permission of the court. And you cannot lease any part of that property of the minor for more than 5 years or for a term exceeding 1 year beyond the date of his majority. Suppose there is a minor child who is of 12 years age right now, and I am the guardian of that child, and I want to lease out the property of the minor. So I can lease it out, but once that child will become a major, and when will he become the major? I will tell you. Suppose he is becoming the major after 4 years or after 5 years or after 10 years. So during this time period, everything will be there in the picture, but once he will be getting his majority, he will challenge this transfer by me. And the language goes like this: if you lease out the part of the property of the minor for a term exceeding more than 1 year beyond the date on which the minor will attain the majority, means the age of majority, the date on which he will be measured, after 1 year of that date, he can repudiate that transaction. So these kinds of provisions or the powers are being given to the natural guardian. Means his power, means the natural guardian's powers are not absolute ones. It is a restricted one. And after that comes section number 9, which talks about the testamentary guardian. Means the father can make a will before he dies that Mr. X will be the guardian of my son or my child after my death. Now, suppose a father dies after making this will regarding the appointment of a person as the guardian of his minor child, and in case the mother is still alive and the father dies after making the will. So two persons are there in the picture. One person is that person who was mentioned as the guardian in the will of the father, and on the other hand, the mother of the child is still alive. So in that case, that person who was appointed by the father will not be the guardian, the mother will be the guardian. And if the mother dies before the death of the father and the father has made the will, in that case that appointed guardian will be the guardian of the child. So such kind of a situation is there under section number 9. Means testamentary guardian may be appointed by the father as well as by the mother. Both the persons are entitled to make a testament, to make a will regarding the appointment of a guardian of the minor child. And what is section 10? A minor person cannot be the guardian. That is the generalized idea, but so far the language of section 10 is concerned, it is very tricky, very tricky. It goes like this. I will read it out just because I want to help you. A minor shall be incompetent to act as guardian of the property of any minor. Means a minor cannot be the guardian of the property of another minor, but he can be the guardian of the person, means the body. It is very important. I will mention this. Section 10. Section 10. A minor. The question is, can a minor be a guardian? Can a minor be a guardian? Minor be a guardian? This is the question. This question may be solved with the help of section number 10. So, language of section 10 says that a minor shall be incompetent to act as a guardian of the property of the minor. A minor will be incompetent for the property of another minor. So, suppose we know that guardianship is always related to the person, means the body of a minor, and sometimes the guardianship is connected with the property of the minor. So, the guardianship of the body is one thing and guardianship of the property of the minor is another concept. So, section 10 goes like this: a minor will be incompetent for the property of the another minor. But what about the body? If one minor is there and the second one is there in the picture, so can the first minor become the guardian of the second minor? In certain situations, yes. Suppose we are talking about the child marriage. So, in our society, in Hindus, child marriage is a valid marriage, although it is punishable. So, if the husband is a minor and the wife is also a minor, but according to section 6, we know that once a girl is married, husband will be the natural guardian, and if the husband is a minor, it means that husband will become the guardian of the minor wife, means that person will be, means the minor husband will be the guardian of his own minor wife. It means a minor person can be the guardian of the person or the body of another minor, but a minor person cannot be a guardian of the property of the minor. A minor can be the guardian of the person, person means body, of another minor, of a minor, but he cannot be the guardian of the property of the minor. This is one question which is very important, it may be asked in your interview. And then comes section number 11. Section 11. This section talks about the de facto guardian. De facto means by the fact itself. The literal meaning of this maxim, de facto, means by the fact itself. Means, suppose there is a minor person and parents of that minor are dead somehow. So, who will be the guardian of that minor? Of course, there will be some family members, some friends who are really interested in protecting the child. So, those persons, by the fact that they are the members of the family, they will become the guardian. Means the court is not going to appoint those persons to be the guardian of such a minor. By the fact, they will become the guardian of the person, that is a minor. Means if the parents of a minor are dead, the uncle or uncle's wife or uncle's brother or whoever is there in the family, that person will become the guardian. So, it is called de facto guardian, means there is no interference by the court. Then comes section number 12. Section number 12. Section 12 talks about guardian not to be appointed for minor's undivided interest. Suppose there is a minor person, a child is there in the joint Hindu family. It means other major members are there in the family. So we don't need to appoint any person to become the guardian of such a minor person, because the property of that minor will be protected and taken care of by the members of the joint family itself. So it talks about the undivided joint family, undivided Hindu family's property, in which the minor is a member. And then comes section 13. Section 13. Section 13 talks about the paramount consideration. What is that? It is the welfare of the child. So the welfare of the child will be the paramount consideration whenever there is a guardian in the picture. That guardian will be the guardian only when he is really interested in protecting the interests of that child, means he is or she is interested in the welfare of the child. So the child's welfare is the paramount consideration, and even particularly when the court is going to appoint a person to be the guardian, the court will be considering this welfare of the child, means who is the person who will be the best person to protect the interests of that minor child. That person can be appointed by the court as the guardian of the minor. So this is the structure, this is the overview, this is the framework of HMGA. But the great details are still pending, and we are coming up with so many videos on different subjects time and again. So please stay tuned with us on our YouTube channel and get all possible benefits from these different videos. Thank you so much.